The police are knocking on your door right now. What you do in the next 5 seconds could decide the outcome of your case, even before a single question is asked. Most people stand up, turn the handle, and open the door on autopilot, and that's exactly where things can start going wrong. There's a simple, short phrase that I recommend my clients use in that moment, and it can protect you in ways you can't even imagine. Today I'm going to show you exactly what to say and why. Before we continue, if you value knowing your rights, hit like and subscribe to the channel. It's 9 at night, you're home, relaxed, and suddenly you hear knocking at the door. Your heart races. Most people's first reaction is automatic. Stand up, walk to the door, turn the handle, and open it, without thinking, without asking, without hesitating. But I need to tell you something that almost no one stops to think about. The real problem can start before the police ever ask a single question. The simple act of opening that door already begins an official interaction. From that instant on, you're no longer just a calm resident inside your own home. You become part of an encounter that is being observed and recorded. The moment the door opens, the officers are already watching everything. Your nervousness, the way your voice shakes, saying, "Good evening," your hands, not knowing where to put them. Every gesture can be remembered later if the case ends up in court. And it doesn't stop there. I've seen many clients who, out of nervousness and trying to seem cooperative, ended up saying too much. "I didn't do anything. I don't know what you're talking about." Words said on impulse, which can later be used against you in ways you never imagined in that moment. Once the door is open, there's no going back. That's why this first second between hearing the knock and deciding what to do is the most important moment of the entire encounter. It's not about having something to hide. It's about understanding that by opening the door, you hand control of the situation to someone else. The good news is there's a different way to respond, a way that protects you without creating confrontation, and that's what I'm going to show you now. I want to explain a principle of American law called the plain view doctrine. It explains one of the most common mistakes I see clients make during a police encounter at home. The principle is simple. Anything an officer can observe from a place where they have legal permission to be like your doorstep can be considered valid evidence. No warrant needed. It just has to be visible. Picture a real scenario. An officer knocks. Someone stands talking in the doorway for too long, without realizing they're creating a window of observation. During that time, anything within view technically becomes in plain sight. And what's in plain sight, under this principle, can end up in a police report. The problem isn't having something illegal at home. The vast majority of my clients never did. The problem is not knowing this rule exists, and therefore not realizing how small decisions like how long you stand talking in the doorway change what can be used later. I deal with cases all the time where the client did nothing wrong during the encounter itself, but unknowingly created a situation where irrelevant details ended up in a report simply from not knowing this principle. Knowing this isn't about distrusting the police. It's about understanding the rules before you play. In the next part, I'll show you the exact question I recommend asking first. The first step isn't opening the door. It's speaking through the closed door, yes. This is completely legal and asking a simple question. "Officer, do you have a warrant for this address?" That question changes the entire dynamic. Before it, you react on instinct. After it, you're in control, seeking objective information before acting. It's not confrontation. It's exercising your right to know before you decide. Any American citizen, innocent or not, has the constitutional right to ask this before allowing entry into their home. This is the Fourth Amendment, working exactly as it should. If the answer is yes, the next step isn't to argue through the door. It's to ask to see a copy of the document and check two details, whether it's signed by a judge and whether the address exactly matches yours. Warrants need to be specific. A generic document without a signature or with the wrong address completely changes how the situation should be handled. This initial question isn't about challenging any authority. It's about turning panic into clarity. In the next part, I'll show you what to say when the answer is no. We've reached the most important moment of this video. You asked if there's a warrant, and the answer was no. There's a phrase I recommend my clients use exactly in this moment. Without a warrant, I will not open the door. If there is a real emergency, tell me exactly what it is. Otherwise, I am exercising my right not to open the door or to not continue this conversation. This phrase doesn't attack, doesn't question anyone, doesn't create confrontation. It sets a clear boundary based on a right you already have. Its strength is in its simplicity. It doesn't sound like an excuse. It sounds like someone who knows their own position and is willing to hold it calmly. There's an important exception built into this phrase. If there is a real emergency. American law recognizes specific situations, imminent danger to life, immediate pursuit of a suspect in which police can act without a warrant. That's why the phrase asks for clarity about this. If there is no emergency at all, your right to keep the door closed remains firm. I want you to memorize these words because the moment you need them most is exactly the moment you're least able to think clearly. There's a part of this that I almost never see explained, and this is where the real value of everything lies. Even if the door ends up being opened somehow, your rights don't disappear. Every American citizen has, under the Fourth Amendment, the right not to have their home searched without a warrant or without a legally recognized exception established by the courts, called exigent circumstances, a real emergency situation. Outside of these exceptions, a search conducted without judicial authorization can be considered illegal. And this has a huge practical consequence. If the search was conducted improperly, what was found can in many cases be excluded as evidence. This is called the exclusionary rule. Another little-known right, you can record the interaction. In practically every state, it's legal to record audio and video of an encounter on your own property, as long as you don't physically interfere with the officer's work. A clear recording can become the single most important piece of evidence in your defense. If, despite everything, entry happens without your consent, say loudly and clearly, "I do not consent to this entry." Do not physically resist. That can lead to a separate charge, even if the entry itself was illegal. Note down names, badge numbers, times. This kind of information is exactly what I later used to turn around a case that started off wrong. The real knowledge here isn't about winning an argument at your front door. It's understanding that your rights don't end when someone ignores them. They continue to exist and can be used later, with far more force, inside a courtroom. If this video helped you better understand your rights, hit like right now. It helps this content reach more people who need to know this. If you're not subscribed yet, subscribe now. Here, I keep bringing you, every week, practical information about your rights and about what to say in the moments most people don't know what to say.